Hey, I'm firearms attorney Gilbert Ambler, and I'm back with a different subject today to talk about. We're here to talk about Alec Baldwin, which many of you have been paying attention to, and many of you were shocked that he wasn't prosecuted earlier after the unfortunate incident that occurred during the filming of the Rust movie. But before we dive into this subject, if you have not yet hit that subscribe button, go ahead, hit that subscribe button, and because we're a new channel, make sure that your friends know about us as the place to go get Pro 2A content. I want to make sure that everybody hears this because there's some important information that we need to talk about. Now, Alec Baldwin. He has not been a friend to gun owners, and for that reason, many people were anxious and actually wanted to see him get prosecuted for this because he had made so many disparaging comments over the years. He said nasty things about gun owners, and then he went and had this incident where he pointed a loaded gun at somebody and ultimately killed another person. Now, I actually have some sympathy for Alec Baldwin. And I have some sympathy for Alec Baldwin because the rules of gun safety are meant to be idiot-proof, and obviously he violated some rules here, but A, he probably never received the education that he should have had on firearms, and B, out of all of the scenarios where you might violate the rules of gun safety, one of those scenarios that I can actually imagine is on the set of a movie. And yet, if you're going to violate rules of gun safety, I contend that you need to be more careful, not less careful with the firearm that you have. I don't think you can rely on what other people are telling you. And so for that reason, I am not surprised that the prosecution is moving forwards and coming after Mr. Baldwin. Why I am surprised is Mr. Baldwin has virtually all the money you could have to hire the best defense attorneys and the best experts and prepare himself for this prosecution, but that has not been what he has done. Because what he has done has gone on and on the record, done recorded interviews, and made statements about what happened that day. And this violates the very basics of preparing to defend yourself in court. Everyone knows, because we hear it, you turn on cops, you hear this said, what you say can and will be used against you, and that's absolutely true, but I want to talk about why it will be used against you. Because the why is important, and the why is the rules of evidence. Okay? The rules of evidence govern what an attorney is allowed to, or what anyone for that matter, is allowed to present in court. Okay? The rules of evidence tell us what things we're able to talk about and what things we're not allowed to bring up. And generally speaking, things that are said outside of court are not admissible to be brought up in court because they're typically hearsay. Okay? Hearsay is an out-of-court statement for the truth of the matter asserted, and if it's an out-of-court statement for the truth of the matter asserted, generally not going to be allowed in court. However, the rules of evidence also govern things that are either not hearsay, even though they would otherwise fit that definition, or an exception to the rule of hearsay. At least under the federal rules of evidence, Rule 801 says that the admission or the statement of a party opponent is not hearsay and is therefore admissible in court. When the state prosecutes Mr. Baldwin, he is the party opponent for the state, and that means the state will be able to introduce his own statements against him, and this is true whether or not he invokes his Fifth Amendment and decides not to testify at trial, because it would probably be wise for him not to testify at trial. That's the importance of the Fifth Amendment right. That's a right that he has. But they've already got statements that they can use against him because he went on, did interviews, and said he did not have his finger on the trigger. And of course, we know from both common sense and we know from the FBI tested the firearm at issue. The FBI has said that firearm will not fire unless your finger is on the trigger. And of course, this is true for most firearms. There are exceptions for a very small type of revolver or a very old type of revolver design that could potentially fire without your finger on the trigger. But we know now from the FBI that that does not apply to this particular gun. This gun, the gun that was used, someone's finger, something had to be pressing the trigger. And so now that Mr. Baldwin has made statements that his finger was not on the trigger, even if he doesn't testify at trial, the prosecutors will be able to introduce those statements against him, and frankly, they're going to make him look like a liar to the jury because of those statements. And he's taken away what might be a better defense for him, because it might be a better defense for him to say, Yes, I pointed the gun at somebody else. Yes, I put my finger on the trigger. I did so because I was told the gun was empty. That wasn't negligent of me. I should be able to rely on the other people that I'm working with. That might actually be a better defense, but he's really, really limited that defense by opening his mouth and instead making himself look like a liar. So this is a high-profile example of why you should not make any statements in the aftermath of an incident that is going to receive a police investigation like this. I have dealt with these cases, and typically when they're not celebrities, they get charged far more rapidly. I've dealt with these scenarios where people just accidentally discharged a firearm inside their home. Nobody gets hit. They still typically get hit with a felony charge for discharge of a firearm inside an occupied structure. And so in this scenario, many of us expected Mr. Baldwin to eventually be charged. It will be fascinating to see how this plays out in court, but he's already starting at a disadvantage because he foolishly made statements after this incident on the record, statements that can be used against him. And there's a lesson for all of us here. The lesson for all of us, if we're ever in this scenario, don't go talking about it. If you're ever in a scenario not where you've accidentally shot somebody, but where you've intentionally shot somebody, a self-defense style scenario, don't go making statements. Talk to a lawyer. Keep your mouth shut. Do not give the prosecution your own words to throw back against you. As always, go ahead, hit that subscribe button if you have not done so. As this trial moves forwards, we're going to keep you updated about what is going on.